Good morning, everyone. I want to thank you for your time today for this lunch and learn. I don't know if you're having lunch, but I do hope you will learn something today. We have with us Gray Proctor, and he's going to discuss with us the all important Jarkesy case that affects so many of the regulatory matters that we engage with as attorneys. And with regard to this state agency that I work with, the Department of Community Health, and along with Medicaid and CMS and HHS, it is definitely germane to the work that we do here. So I'm going to move this away from me and give you the man for the hour, Gray Proctor. And thank you so much for attending. And if you haven't joined the administrative law session, you get a break. You can join for 1250 for the remainder of this session, remaining of this year. So thank you so much. And that is July. That's the remainder. Thank you so much. If you haven't joined, please do so. Gray, please take it away.
Okay, well, thanks very much, Tara. I'm Gray Proctor, and I'm coming to you from Castellanets LLP. Today, we're going to talk about SEC versus Jarkesy at 18 months, where we are and where we're going. I've been really lucky. Go ahead and hit the next slide, if you would, Tara. Like everybody else, I've been to some schools and I've had some jobs. I see people chiming in now. Thank you very much. I've had some jobs, and I was a solo practitioner for a good while in Florida. But what's interesting about me is that I've been lucky enough to work at Castellanets LLP for the past couple of years. It's a really stellar firm. We practice in tax controversy, especially tax fraud defense. And we really specialize in guiding our clients through joint civil and criminal investigations, especially on the tax side. Why does this matter to you folks? Well, we have plenty of former government employees, including Karen Kelly, former head of DOJ tax when there was such a thing, Victor Suthamanat, who was a former enforcement counsel to SEC Chair Gary Gensler. And we also have Caroline Sorallo, who's a former acting attorney general of DOJ tax. And I was going to ask for a show of hands from all the government service, but I see most of you have turned your cameras off. So that's fine. I assume you're out there. And I just want to say that we've been on both sides of the V, and I'm going to try to be objective with you about Jarkesy today, even though we are litigating some of these issues right now, and we do have an interest in the outcome. Next slide, heading is course description. I hope there's something for everybody today. The course description is a little bit redundant to what we're actually going to talk about and to these. Next slide, please, the one that's entitled Learning Objectives. And for those of you who are about to take a nap, here's the whole thing in a nutshell. Today, I want public rights to enter your lexicon. I want you to remember that equitable and legal jurisdiction are historically distinct, which you kind of remember from 1L year, even if you don't think you do. We're going to go down a fun little rabbit hole that illustrates how Jarkesy works with tax penalties. And from there, we're going to back into the question of when the jury trial has to happen, when Jarkesy requires one. And from there, we're just going to hit on a smattering of the most recently decided cases. Obviously, this is still working its way up. Next slide, please. The one that says timed agenda. There's an asterisk there. This agreement is for novelty purposes only and is not enforceable. Next slide, please. The one that says introduction from text to two steps. So we can get into the material now. Like I said, we're talking about the public rights doctrine today. And public rights is the name that we give to a few groups of exceptions to the Seventh Amendment. As long as the court has been talking about public rights, it's been giving taxation as the primary example. It's been saying taxes are the lifeblood of government. We do not have time to leave this to 6 or 12 random people that we grab off the street. Taxes has been that. Other examples are public health, immigration, and international trade. On the surface, all of these are a long way from SEC versus Jarkesy, but Jarkesy is a big case and it's affected administrative remedies in lots of sometimes unpredictable ways. There's still a lot of unanswered questions, and we really can't understand where we are without having some idea of where we've come from. So with that, let's start with public rights. Next slide, please. No, I'm kidding. We're not going to start with public rights, though. What we're going to start with is the text of the Constitution. And you'll see there's nothing in here about public rights. That turns out to be very important to the analysis later on. Instead, what we see is the Seventh Amendment, which applies to suits at common law. We also have Article 3, which describes the judicial power of the United States. Now, obviously, the text is different here. It doesn't line up with a suit at common law. Things might change, but for our purposes today, Article 3 applies when there's a suit at common law. So, where you have the right to a jury trial, you also have an Article 3 right to an independent judge as well when you're in the federal system. Next slide, please, the two-step. So it's only after we find a suit at common law that we can really dance the Jarkesy two-step. And that way we can get to public rights at step two. So another disclaimer, you see that quote at the bottom there? I hate it when the Supreme Court says things like that. And that's from Jarkesy. And you see the quotation marks. It incorporates quotes from earlier cases too. The courts have been kicking the can on defining public rights for a really long time. And all Jarkesy does is sweeps away everything we thought we knew about it. So let's look at some examples and let's look at how public rights started when they first came around. Next slide, please. Public rights before Jarkesy. So in this first era, we have specific examples of government power that are thought of as being somehow essential to a sovereign nation. And the unifying thread here is just things that are inherent in the idea of government power. So next slide, please. Public rights from 1856 through 1977. This is a long slide. I'll walk through it quickly. You can keep your eye on the ball by looking at the list of the summaries of cases I put there for you, but I'm going to walk through each really quickly. Murray's lessee number one was a tax case. It features a tax collector with the unfortunate name of Samuel Swartwout. So, with a name like that, he's going to break bad. And an audit of his accounts reveals a deficiency of about 1.3 million unpaid. To collect this from the tax collector, the government uses a procedural advice that's called a distress warrant. And it immediately grabbed Mr. Swartwout's real estate and used it to satisfy the debt at resale. But another one of Swartwout's creditors got title to the land through different proceedings. And the person who got him through those proceedings argued that the federal government never really got them because there was not a jury trial. Murray's lessee loses. It's okay to just snatch that land back from the tax collector who has not turned over the money to the United States government. And here's what the court says about public rights. There are matters involving public rights which may be presented in such a form that the judicial power is capable of acting on them, and which are susceptible of judicial determination, but which Congress may or may not bring within the cognizance of the courts of the United States as it may deem proper. Okay, so that's a big one. Murray's lessee also talks about history and practicality here. It recognized that there's this distinction between people who hold public money and other defendants. So, in a way, this tax collector is kind of asking for it when he takes a job with the United States and then doesn't give the money. And the decision also points to the imperative necessity of tax collection. And what it says about that is that there are probably few governments which do or can permit their claims for public taxes to become the subjects of judicial controversy. Okay, so number one, public rights start with taxes. Number two, oceanic steam. This is an administrative penalty for taking a passenger who was sick and whose sickness could have been detected at the port of departure. The Oceanic Steamboat Company had to pay the penalty to the tax collector at the port because otherwise they would have been denied clearance to leave. And so, where the absence of a jury trial comes in here is that the factual question, whether the existence of the disease could have been discovered by a competent medical examiner before the departure, that's what was decided without a judge when they imposed that penalty. Here's the court's reasoning. In view of the absolute power of Congress over the right to bring aliens into the United States, as a condition to the right to bring in aliens, a penalty for every alien brought to the United States afflicted with a prohibited disease is permissible. They talk about Congress's absolute power. And reading between the lines, they also seem to assume that penalties that are related are themselves within the public rights exception. So that's oceanic steam. Bakelite is another important case in 1929. This is an international trade case under the Tariff Act of 1922. Bakelite objects to the case going to the Court of Customs Appeals. And in the Supreme Court, Bakelite argues that the Court of Customs Appeals was an inferior court of the United States and that it couldn't issue an advisory opinion. So this is a little weird to think about, but Bakelite is in the position that it wants the Court of Customs to be an Article 3 court. What happens at Bakelite is there's a holding that the Court of Customs Appeals is a legislative court, and that's okay. So international trade becomes an area where penalties can be imposed without any kind of jury. Number 4 is Phillips. This is tax liability again, but it's a little bit different. In one way, we're close to primary tax liability here. What happened in Phillips was that a corporation's tax debt was satisfied by its shareholders. Its shareholders had received a portion of the assets when the corporation dissolved. So what's at stake here is a determination of transferee liability. This is 1931. They're still figuring out how to have an administrative tax code, and the administrative state is developing. And so what's at issue in Philip is a new statute. Under the old statute, transferee liability had to be established by a bill in action, a bill in equity, or an action at law. The new statute took that away. So it puts in the agency's hands the determination of whether transferee liability exists. The Phillips court disagrees, and I guess the important thing here that the Phillips court did was, of course, it looked back at Murray's lessee, but it said, no, 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 Murray's lessee doesn't have anything to do with this special relationship that a tax collector has with its employer, the United States. Murray's lessee is about tax and the need of the government to promptly secure its revenue. So take a breath. Big picture, we see some other cases during this period. We mentioned immigration. There's Indian tribes as well, and some other miscellaneous ones. Less important than what each public rights exception is really how we're thinking about it here. We're thinking about key government functions. And with oceanic steam in the mix, we're also maybe thinking about penalties that are related to those functions. Tara, we're finally ready for the next slide. Thank you. That's where we are when we get to Atlas Roofing in 1978. And look at this quoted text. You see Atlas Roofing recognizing this approach, right? Powers that are inherently the exclusive domain of the government and critical. But we're in a much different time when Atlas Roofing is decided. Of course, as you all know, I'm sure you're all students of history, in the mid to late 20th century, we start to see a modern regulatory state and we start to see penalties. We have OSHA in 1970, we have EPA in 1970, we had EEOC as far back as 1964. And in general, we're just seeing an increasing social regulation of health, safety, and the environment. So Atlas Roofing is about OSHA penalties. And in Atlas Roofing and its companion case, we have two companies who are hit with fines for violating regulations. One's for improper roof covering, one is for improperly sloped trenches. The penalties here, by the way, were 5,000 and 600. So, what we're really concerned with in Atlas Roofing is how the court treated the public rights exception. It recognizes where we came from, but next slide, please. To causes created by statutes within the power of Congress to enact. So, as usual, this is something you have to look at it a couple of times before you realize what they're trying to say. But the reasoning in Atlas, which was a unanimous decision, was that when Congress creates these statutory enforcement regimes, it creates them by statute. You don't need a jury. When Congress creates new statutory rights, it may assign their adjudication to an administrative agency. So that's much broader than we were before. This is a new category that threatens to make everything a matter of public rights. We also see broad language about the public rights taxation exception in this case, of course, but that's less important to you here today. Next slide, please. A bang or a whimper. Atlas Roofing was by far the most expansive decision on the public rights doctrine. And in general, after that, we see a period of narrowing. Um, Back here now, in 2026, we're wondering what Jarkesy means. It turned out that Atlas Roofing didn't necessarily mean all that it said. To look at this first case, in Northern Pipeline, the court declined to expand the public rights exception to cover bankruptcy generally, so that the bankruptcy court could exercise supplementary jurisdiction over all of these claims. The bankruptcy court, another example, not an Article 3 court, Article 1 legislative court. There are lots of claims between creditors and debtors and counterclaims. And the question is always, how much of this can the bankruptcy court decide? What Northern Pipeline holds is that Atlas Roofing does not apply to claims that were not created by Congress. So we can't hear these common law claims, which, looking at the text of the Constitution, might not surprise you. In 1985's Union Carbide case, Thompson versus Union Carbide, we have claims under FIFRA, which is the Federal Insecticide, Fungicide, and Rodenticide Act. This, bear with me, it's a strange statutory structure. There's arbitration of disputes on compensation when the first one to market, who has to register an insecticide or a fungicide, the first one has to pay fees and do lots of research, and behind them, there are follow-on registrants. If they can't agree on the amount of compensation that should go to the first one, then there's an arbitration process for that. What happens here is the holding that the right to be a follow-on registration is not a private right. But really, what's key here is that the public rights exception does not apply only when the government is on the other side of the V. And here you have it between two private parties. 87, we have toll, and that deals with civil penalties for EPA violations. The this is I'm hemming and hawing because I don't find a lot to say about toll, right? It's EPA violations. It's a penalty. What's important to me about toll is kind of a strange holding that you don't have to submit the amount of the penalty to the jury. The holding is that since Congress could have put a mandatory penalty on it, then the amount of the penalty can be decided by an executive agency. And so in 1989, by the time we get there to Grand Financiera, we have the author of Atlas Roofing protesting that Atlas Roofing has now been overruled. The majority writes that even when an action originates in a newly fashioned regulatory scheme, what matters is the substance of the action, not where Congress has assigned it. And so in grand financiera, what happens is Congress won't let the bankruptcy court hear the bankruptcy trustee's claim to recover a fraudulent conveyance. But Justice White recognizes that that formulation of the rule really leaves Atlas Roofing in doubt. And that is where things stay for maybe longer than you'd expect. Next slide, please. That's where we are when we get to the Jarkesy era. I'm going to play a little soundbite here for you if I can, by the way, because this is an ongoing problem. I think we all.
Your argument this morning in case 22-859, the Securities and Exchange Commission versus Jarkesy. Mr.
So we do hear the name being pronounced a lot of different ways. So don't feel bad if you had trouble with it. But Jarkesy is an SEC penalty case. And we have the SEC seeking penalties against George Jarkesy Jr. and Patriot 28 LLC for securities fraud. And there's a whole host misrepresenting investment strategies, lying about who is the auditor and who's the prime broker, and inflating the fund value. What the case brings is a constitutional challenge to the Dodd-Frank Act. And in 2010, it gave the SEC the power to seek these penalties in in-house proceedings in front of an ALJ. This course this case is really interesting, and especially interesting, I think, are the statistics of the win-loss rate of the administration, the SEC in front of their own ALJs. For a good long time, it was 100%, and there's still a marked differentiation between the results you get in front of a jury and the results you get at the ALJ. So those things are interesting, but this case really should have been easy under Tull and Grand Financiera. The Jarkesy court, we have a very conservative court, we have an originalist court, some have called them activists. Jarkesy went a lot further, and it upends how we think about the public rights exception. It takes all of these foundational public rights cases that I just talked to you about. Next slide, please. Jarkesy completely recasts. All those cases we just talked about are no longer public rights cases. They are cases that don't involve a suit at common law in the first place. So none of them need the public rights exception. It doesn't give us too much in the way of reasoning for these cases, but it does explain why it did what it did with Atlas Roofing. And here's what the Jarkesy court says about that. This is depending on where you practice. This might sound like the kind of code that you deal with. Unlike the claims in Grand Financiera and this action, OSHA did not borrow its cause of action from the common law. Rather than reiterate common law terms of art, they instead resembled a detailed building code. And so that's the idea, right? You have the general idea of, say, negligence or being reasonable, being careful enough. And that's a common law concept. But specific measurements, things that resemble a building code, well, that's just not a suit at common law. So, okay, we get that. But what about these other cases? Why weren't they suits at common law? I've spent a lot of time trying to figure out why, and I'll share my guesses with you shortly. But I want to stay with public rights a little bit longer. We have now upended the public rights exception. And let me just say that again. It's still out there. There's tons of dicta on it. But where is that case where you have a suit at common law and then say, but the Seventh Amendment does not apply? I don't know where that case is now. And so you remember all the way back from slide one, arcane distinctions and confusing precedents and not being able to state a definition. So the majority opinion is not helping, and they're even being a little coy about what they've done because I think this is big. They leave us with this vacuum. And next slide, the concurrence. They leave us with this vacuum. They kick our legs out from under us, getting rid of all these public rights cases. The concurring justices do have an idea, and it is originalist. It's difficult not to think about these things in political terms sometimes these days. But I'll say that it's hardly out of the mainstream of conservative legal thought. So this is not a place where I necessarily feel like Thomas and Gorsuch are way out in front of the rest of the majority. But the concurring justices first take the time to throw some shade on the doctrinal basis for the public rights doctrine. They talk about the competing explanations, practical necessity, and the public-private rights distinction. They don't see much there. And unsurprisingly from these guys, next slide, please. They have a solution, and it is an originalist one that's rooted in history. They find the common denominator for all of these categories in demonstrable historical practice. So I don't think this is a really surprising approach. I mean, I think it's not to talk about who believes what in their personal lives, but this seems consistent to me with conservative doctrine. And I wouldn't be surprised to see it become important or even outcome determinative here. And I think that the way to express the practical difference in this is that you are looking for historical evidence that we did this or something closely analogous to it in the past. It's not enough to think, oh, this is the kind of thing that's a good idea. This is the kind of thing that is important for a government to do so we can allow it. We have to go back and we're thinking about what the founding generation meant when they said suits at common law. So it makes sense to me. I feel like it's an idea whose time may have come. So next slide, please. The new presumption against public rights. This I've seen talked about a little bit less than the adoption of the historical approach, but it's an important shift because whether it's going to be history or history plus or something else, now the public rights inquiry is going to take place on a battlefield that is unfavorable to the government, and it's because of this presumption. This is another example. I've cut the quote out for you, and you can see how many quotes we've had before, right? You've seen this expressed in plurality opinions before. Now the majority comes out and says the presumption is against finding a matter of public rights. So that just changes things. I think that's a new era of skepticism towards administrative power. And with that, let's turn to the next slide, the suit at common law element. The public rights exception has gotten a lot harder to get through, so there's going to be pressure to win at this point if you're the government. Jarkesy didn't purport to make any really big changes here, but there hasn't been a lot of attention paid to it as well. And I think it's useful to identify where the cases Jarkesy has now said are not about public rights. Where do these cases drop out? And I'm talking about Atlas Roofing, Murray's Lessee, Mitchell, Oceanic Steam, and Bakelite. So next slide, please. How do we know we have a suit at common law? We have two tests and they are not distinct. They have an ill-defined relationship to each other. But the overall yardstick here appears to be that a suit in equity is taken solely to restore the status quo. So if you have a mixed action that partakes of both common law and equitable characteristics, it's likely going to be treated as an action at common law that deserves a jury. The first test we're going to go through is remedies. The court has said that that is more important, but the analogy test matters as well. Next slide, please, Tara. So equity 101, if you had remedies, I took it 3L. I was looking for an easy class. I'm not sure how many people did. Hopefully some of this is familiar to you, though, because you know at least a little bit about equity. The rule that Jarkesy has announced is that money damages are the prototypical common law remedy. So let's start with the prototypical equitable remedies. They're not monetary. They include injunctive relief to command or prohibit a certain action. Is this where Bakelite fell out by analogy to an injunction against trading those goods into the United States? Specific performance is another example. A contract for sale of land, right? That's categorically unique. Monetary relief is insufficient. Replevin, less likely to have encountered your 1L year, but it does the same thing for specific personal property. And there's some things that act directly on legal status, rescission or reformation, declaratory relief, kind of. Equitable title is out there. But overall, these are the easy questions. Where it gets more difficult, next slide, please, Tara. Where it gets more difficult is at Equity 102, when we're thinking about what kind of monetary relief equity might offer. So, to start with, when we talk about this monetary relief, I think that the status quo language has thrown a lot of people off. Jarkesy is quoting Toll here when it talks about the status quo language. Some people seem to want to put compensatory damages for personal injury in there, and they do not belong in there. Negligence is a prototypical common law case. Compensatory damages are not equitable damages. So we have to be disciplined about this, and we unfortunately do have to go back and look at these cases. So, what's easy? Punitive damages, including punishments meant to deter, those fall right out because the purpose of those is to punish. And looking at the damages that are recoverable, looking at the theory of damages, treble damages obviously fall within this category. They're meant to punish. But that's the question we're asking ourselves when we're talking about the remedy. What's the theory according to which the damages are calculated? Um, One good area to draw from are the remedies that apply when there's no contract. Depending on your jurisdiction, we're talking about unjust enrichment, disgorgement. Depending on where you are, these can be causes of actions, or they can just be descriptions of the damages. But the key here is that the damages have to do with this abstract idea of the scales of justice being balanced. And that's a frustrating way to have to put it. But in unjust enrichment, the problem is that somebody gets something they don't deserve. And so, and with disgorgement as well, right? The focus is on keeping someone from not profiting by their wrongdoing. In common law, we do see this sometimes with a fiduciary relationship aspect. But the key here, the measure of the relief is the gain to the other party. There's a big case right now, this Repech case, in the Supreme Court that has to do with equitable disgorgement on SEC remedies. And so we're still exploring the limits of this and how it interacts with everything. And the last kind of monetary relief I'll mention is the constructive trust and the remedy of tracing. Here's a situation where you tend to see mishandling of funds or a flow of funds that were held for someone else or should have been used to pay an obligation. Um, these are equitable, and these remind us maybe of Murray's lessee, where the tax collector had that kind of relationship. And then in Phillips, we had a shareholder who received corporate funds. So those funds are somehow tainted with the tax obligation. But it resembles the tracing function anyway. Big picture, these are the kind of theories you're looking for. If you're trying to put the equity label on some kind of monetary relief or penalty, you want to see some kind of legal gymnastics on the measure of damages side that gives you a basis to differentiate from compensatory damages and other forms of legal damages. Most penalties fail this, candidly. They fail it quite easily. Next slide, let's go to analogizing a recognized suit at common law. And this is kind of what happened with Atlas Roofing, right? In Atlas Roofing, the court said it couldn't find a suit at common law. So the relief available is supposed to be the most important, but this is important as well. Again, it was the main basis for distinguishing Atlas Roofing. Um, when it comes to penalties, aside from pointing to state of mind requirements like fraud or negligence that resemble common law doctrines, so we have those where we have a mens rea. The important thing in Jarkesy is you have a generic penalty cause of action that was a suit at common law in history. It's been called an action in debt, and oddly enough, it makes penalties analogous to suits for breach of contract. I'll turn to Blackstone. You haven't read him in a while. I haven't read him in a while, but in 1777, he was all the rage. And he explained in his commentaries that due to an implied contract to submit to the rules of the community, penalty statutes create a debt in the eye of the law. So after this has always been around, it hasn't been emphasized so much, but after Jarkesy, we clearly see every time you have a penalty, you can point to a suit at common law that it remembers. So this changes the landscape quite a bit as well. And we hope to find out what's going to happen sooner rather than later. Next slide, applying Jarkesy. So let's get into that now. Let's get into how Jarkesy is being applied. And I hate to do it to you. I am going to have to start with two tax specific applications. Next slide, please, Tara. Aside from giving me a chance to nerd out about tax penalties really demonstrate the importance of being historically precise when you define a category of public rights. I think I said before that taxes are the quintessential example of matters of public right, and they're likely to remain so. So, looking at this after Jarkesy, if you're trying to make a case for tax penalties, the real question was what to do about this recognized tax exception. Jarkesy swept away some of the precedential force of these holdings, but nobody really seriously disputes that there is a public rights exception for tax. And we've had administrative collection of tax penalties since 1918. Actually, Civil War II, we'll get to that. But there's plenty of inertia, and our modern system dates back to 1918. But Jarkesy threw us a little Easter egg here as well. It's cited to a 1978 article that criticized Atlas Roofing. And this points out what I'm calling the secret history of tax penalties. And so, what we see that surprised tax practitioners who are used to the system we've had since 1918, some, but not all, of the penalties in England were being collected in suits at common law. In the colonies, we see a stronger tradition of common law courts taking up penalties and forfeitures associated with tax planning. Of course, at that time, tax penalties, I'm talking about smuggling. Duties and tariffs are the source of the crown's revenue, not internal taxes that we know today. But from 1651, with the Navigation Acts routing all colonial trade through England, we see penalties becoming suits at common law. By 1764, we see discriminatory treatment against the colonists. The Sugar Act of 1764 and then the Stamp Act in 1765. They both created penalties. When the offense occurs in England, there's a jury trial. When an offense occurs in the colonies, the trial is in a court of vice admiralty, which number one has no jury, number two is a military court, and number three, for long periods of time, was held only in Greenland. Just so you actually, or Nova Scotia, sorry, not Greenland, Nova Scotia, but you had to get up to Canada to attend your trial. And they were doing that because the pesky colonial juries would not convict. And so, in addition to this back and forth history, we also have tax penalties being part of the American tradition and being one of the factors that contribute to the Declaration of Independence. And big picture, that leaves us with a lot to digest when we try and unpack what we think the founders thought about tax penalties and suits at common law and juries. But so now to run this through the Jarkesy analysis, at step one, we have a new, more direct analogy to a suit at common law during the first generation of American history, which are tax penalties. Once we're there, if the history is a mess or it's inconclusive, it means that the government can't rebut the presumption that the Seventh Amendment applies because it can't establish that unbroken historical practice. And just between you and me, I was extremely fortunate to be working on this issue in the context of a client who could let me spend a lot of time in history books. This is hard work to do. And if the courts are serious about it, attorneys are going to need to engage with real history here. And that's something that's a big change too. I don't think we should overlook. But as I've said, another thing that's complicated here is we've had summary penalties on income tax almost as long as we've had one. We have the first income tax in 1861, Civil War. The next version of it has the first fraud penalty that is assessed and collected as a tax without a jury. And we've had it ever since. It's become part of our tradition. But some of our clients also face IRS sanctions that maybe resemble the penalties you're more familiar with. The IRS is in charge of a couple of penalties that don't bear directly on tax liability. It can impose penalties on promoters of tax shelter. It can impose penalties for failing to report foreign bank accounts, even if there's no tax due. And there are some penalties for tax preparers as well. And so these penalties came around in the 1860s. They don't stretch all the way back. So even if Jarkesy doesn't get rid of all tax penalties, in some respects, the IRS is in the same position as everybody else. Next slide, please. So another tax relevant issue that's out there is the timing of the jury trial. This is something that varies greatly according to what statutes you're working with. There's a spectrum of agency authority to get money that it's owed. And the one that is on the Supreme Court right now in the AT&T and Verizon cases is probably the weakest one. These are AT&T and Verizon versus the FTC. Here, the penalties that are at stake are failure to take reasonable care to safeguard customer geolocation data to third parties. So this is your phone selling your location. This is a penalty I actually really want to see happen. But the penalty that the FCC imposes here, I would call it a suggestion because at the end of the agency investigation process, AT&T and Verizon got a bill. If they had not paid their bill, nothing would have happened. They could have waited 5 years for the statute of limitations to run, and nothing would happen unless the FCC actually sues them. But they chose door number two. Almost no one does. The alternate route oh, and by the way, they would have gotten a de novo trial. So the agency proceedings really would have meant nothing to AT&T and Verizon here. But they took door number two, they paid the penalty, and immediately appealed the issue to the Fifth Circuit and the Second Circuit. So they won at the Fifth Circuit. The Fifth Circuit's reasoning was that the agency had already adjudicated liability. Second, an after the fact trial does not protect an individual's Seventh Amendment right because there are real world impacts. Third, an after the fact trial doesn't protect an individual's Seventh Amendment right when the after the fact trial is the only opportunity for an individual to exercise her right. So I presented those to you as the Fifth Circuit wrote them. I like the outcome. I'm not too convinced that that's strong reasoning. It seems a little circular to me. According to the second, there's a distinction. The problem in Jarkesy was that the SEC could siphon its securities fraud claims away from Article 3 courts and compel payment without a jury trial. The FCC's forfeiture order doesn't compel payment. So one way to look at this question is, do you need a jury trial before the government sends you a bill? I wouldn't bet money here either way. You're squinting pretty hard looking for something of constitutional magnitude that has happened. But there's an important case in the Fifth Circuit that turns on AT&T. That's the Segu case, and it's currently on appeal in the Fifth. Um, it deals with foreign bank account FBAR penalties. The the problem here is that you can't get judicial review until you pay, number one. And then number two, the IRS has a variety of tricks up its sleeves that most agencies don't have. The IRS, at the end of the day, can use the administrative offset system to collect your tax refunds, to collect any money you're owed through the government procurement system. And of course, they can also file liens. They have lots of things to do to get your money. So that's a big difference in this context. And we are watching closely to make sure that whatever happens in the AT&T case doesn't change what happens in the Segu case. Um, Anyone who wants to join me down this rabbit hole, feel free to shoot me an email after this. I'm happy to talk about it. But for now, let's go to the next slide, Tara. Here's another example of when you talk about the historical tradition, you have to define it appropriately. In Sun Valley here, the issue was violating the Department of Labor regulations that apply to H-2A non-immigrant visa sponsors. I think I got that right. So we have violations of that statute and we have penalties. And they want the government, of course, wants the penalties to not be through the jury. Their answer was public rights exception for immigration. And the court said, no, that's too broad. Not everything that touches immigration or has immigration or a visa in there somewhere. Public rights doesn't sweep up all of that. Sun Valley, the court said, Sun Valley's case falls outside the immigration exception and the tradition that shaped it because it does not directly address the admission and exclusion of aliens. The labor certification process is decided to vindicate the domestic national policy goal of preserving the wages and working conditions of workers in the United States. And this was an area where the labor regulations applied, not the immigration regulations. I believe they were cross-referenced. So I said before, oceanic steam is a particular problem for us in the tax area because we have a tax public rights exception. We want to say that you need more than just some kind of relationship to make the penalties also within them. Sun Valley Orchards is an example of a case that we like on that score. Turning to the next licenses and doing businesses. So this is a bit of a potluck. A lot of these cases raise more questions than they answer, and there's a divergence of opinion. But there are some ideas that are out there that I thought that are really interesting. And if you ever have to litigate any of these, you might want to have run into these and know to look for them. Let's start with Ball, which is a case in New York State Court. At issue in Ball is whether an EMT can have a jury trial after some very serious allegations that are going to result in license discipline. And we've gone over some arguments as to why that might not require a jury. The government is granting a license, a permission to do something, and the government is also allowed to enjoin certain actions. So both of those might fit here, but the Ball court didn't bite on any of them. Instead, the Ball court found that a private right existed because the EMT had acquired a property interest in his license. So that is a bit of a curveball. I don't think many people are thinking that Jarkesy is going to change licensing administration, but it might. But so far, as far as I know, we only have that one case on it. The next case is Exalta. And this has to do with the kinds of regulations maybe we're more familiar with. In Exalta, we had a shipper who was responsible for a can of paint leaking during air transport. And it got fined for violating regulations, and I'm quoting here, defining the technical parameters of conditions considered normal in various modes of transportation. And what does the Exalted Court do? Maybe you can guess. It invokes the Jarkesy Atlas roofing rationale for OSHA type regulations. These are standards that are unknown to the common law. They're technical standards. Also noticeable, if you're a Jarkesy watcher here, is a concurrence from Judge Bibas basically begging the Supreme Court to step in and finish cleaning up the doctrinal mess it caused by not overruling Atlas roofing. Nobody asked me. I personally don't see a big problem with not overruling Atlas roofing, but here's what Judge Bibas said. After Jarkesy, the case law is at war with itself. The result has left us with a theoretical scramble, a public rights exception that the founders understood narrowly, but that precedents force us to construe broadly. So that's out there too. National Presto. The National Presto case is important because it gives us an example of an equitable monetary remedy at work, disgorgement of profits. The losing theory here was that disgorgement was just a proxy for Presto's damages for lost sales, and therefore it's just a legal remedy. Unlike the approach we sometimes see, the court here doesn't care about. Presto obviously wanted to be compensated for its loss, but what mattered to the court was that Presto did not plead or attempt to establish that it had actually suffered any damages. The entire theory of its case from the beginning had been they have profited, they do not deserve profit. This is an unjust enrichment equitable scenario. So, no Jarkesy problem in National Presto. And SEC disgorgement is at issue in Striptech versus SEC. The issue here is whether the SEC, as a matter of statutory construction, can obtain equitable disgorgement where the investor suffered no pecuniary harm. Jarkesy is only mentioned in passing here, but we might emerge with some useful insights on the distinction between law and equity. Or we might get a case that doesn't matter to anyone except people who work with the SEC. And finally, we have another remedy, another split on whether a remedy is legal in the NLRB cases. And these do with thrive damages. That's the style of the case of a 2022 NLRB order awarding them. So thrive damages are under the banner of the NLRB's power to award make whole belief, to make whole anyone who's been injured. And the board has interpreted the statute pretty broadly to allow it to compensate for all direct or foreseeable pecuniary harms suffered as a result of the employer's unfair labor practice. Those look like consequential damages to me and some other courts. Especially, well, we'll talk about Judge Boumtien in a minute. Let's skip him. Next slide, and we're getting to the end here. Thank everybody for their patience. As we wrap this up, if you snuck away or if you fell asleep, you might have, don't let them know this part. A national standard. Right now, we don't have one. And those of you who practice with state agencies might not be thinking that this is going to apply to you. The Ball Court in New York concluded that the Seventh Amendment is both fundamental to our scheme of ordered liberty and deeply rooted, and therefore the Seventh Amendment applies to the states. So the slide we just looked at, that's why the Ball Court was applying Jarkesy. The Delaware Supreme Court has very recently disagreed, and Thomas versus Humboldt, this was a case last year. The case wasn't a good procedural vehicle, so cert wasn't granted, but Justice Gorsuch was very vocal um, in saying that he thinks that the Seventh Amendment applies to the states. He says, it is hard to imagine how the Seventh Amendment might not be among those rights the 14th Amendment secures against the states. And then he lists them all. On what account should the Seventh Amendment be treated differently? So this might unfortunately become everyone's problem. No, it'll make things simpler, of course. We'll all be doing the same law, but we'll all be going through the same changes together. And last slide, please, the epilogue. It looks like we will have time for questions if we have any. So I've said big picture a couple of times. I'm just an appellate guy. And this is what's important to me, I think, the most about Jarkesy. It's been 10 years since Justice Kagan famously said, we're all textualists now. And enough of us are originalists now that if we want to be effective as lawyers, we need to be able to be effective as originalists. And it's just a fact of life. I number myself among those who might want a different approach. But we all have to adapt and we have to find ways to use these tools to get the outcomes that we want. And we have to rise to the challenge of engaging with doctrines we might not like. And originalism is very ambitious. I want to read to you some of the selections from the opening remarks at the Federalist Society Lawyers Convention in November. These are from an address by Judge Patrick Bumate of the Ninth Circuit. And I'm not saying that this is right. I'm just saying to look how energized a component of the judiciary is. The judge says we're in the golden age of originalism. Originalism has won the day on the battlefield of ideas. And he has some modest proposals for those who would call themselves faithful or bloodthirsty, and this is his word, bloodthirsty originalists. Number one, first, it's time we put the mantra of judicial restraint in its place. Judicial restraint rightfully rose to prominence as a reaction to the Warren Court's excesses. Second, bloodthirsty originalists must not hesitate to overturn non-originalist lower court precedent. And so he's talking about the end of horizontal stare decisis there. And third, I'll paraphrase this one, refuse to extend and distinguish precedent when you can't overrule it. And then number four, I thought this was particularly interesting. Don't let the party presentation principle override the need to reach correct legal decisions. You may hear judges talk about how they would love to follow originalism, but they can't simply because the parties haven't presented any historical analysis in their briefing. To me, that's no excuse. So I don't want to make Justice Bumate, I'm sorry, I'm calling him Justice, Judge Bumate, the mouthpiece for the entire judiciary, but this is a public statement. His remarks are going to be influential, and especially with the party presentation principle, if you're not doing this kind of analysis, then the court might just do it for you, and you might lose your opportunity to engage with it. With that, I'm happy to open up the floor if there are any questions. Oh, and let me look at the chat. Whether Jarkesy would preclude FINRA from having to hear matters since party would seemingly have. FINRA often involves. Okay, well, William, let me get situated in the statute because I don't work with FINRA. Is whether Jarkesy would preclude FINRA from that. So, William, the question is going to come down to what kind of damages FINRA is able to get. And, if it's a flat rate penalty, that's a factor. If the Stripetch case is currently pending in the Supreme Court, but one of the issues in that is whether something stops being a penalty when the money is given to the victims. That's an issue out there, and I don't know if that's part of the FINRA structure. Is there a specific, if you can type in, is there a specific kind of damage theory, or can you give us an example of the kinds of damages FINRA usually seeks?
Okay, so FINRA is this weird hybrid of where if you are taking out securities and a broker does something wrong, let's say doesn't advise you on the suitability of your investments, you
Hmm.
can sue the broker for all kinds of things. And it's a private entity that has been created to carry this out. But the damages that are involved, the suits involved are all traditional common law type things where a plaintiff is suing for breach of duty of, let's say, the suitability rule and other things, or fraud or whatever. And it's done through arbitration. I'm a FEMA arbitrator.
Hmm.
So the question is you have this entity that is under the SEC, but it's a private entity that is doing all this. And if you're a broker, you're being subject to traditional common law suits. So when I read Jarkesy being a FEMA arbitrator, I was wondering, since FEMA is in the SEC rubric, so to speak, I was wondering if you have seen any litigation or whether there might be a viable argument
Hmm.
that FINRA, if a party won in the jury trial, the whole thing gets knocked out. That's my question.
Yeah, yeah, no, no. Based on what you described, William, the argument certainly seems there. When you hear the word fraud, right? I mean, that's a red flag for something you expect to see in front of a jury. What I think might complicate it a little bit is that you are in, and stop me if I'm wrong, but you're in an area where you're dealing with people who are licensed, and as a condition of their license, they have agreed to this mandatory arbitration. Is that fair, or?
The brokers who are in this, and again, I'm an arbitrator. I am hardly a FEMA expert.
Mhm.
My practice is actually in the rights of people with disabilities. But as I understand it, the broker is, by being a broker, they subject themselves to jurisdiction. The consumer, by working with the broker, gets fed into the FEMA system, but they're a different kettle of fish.
Yeah, when you're talking about the consumer and you're talking about a constitutional right, it's problematic to just take that. If you don't have some, the the brokers, the people that are licensed, as a condition of your license, my gut feeling is that they'll be able to get away with things like that still. But that is a problem for the consumer. So I wouldn't be surprised to I would hope to
Okay.
be seeing something like that soon.
Well, I was just one, when I read the decision, it seemed to me as a theoretical possibility that the argument was possible. And so I'm glad to hear that I hadn't misread the decision. But again, I'm not aware of anybody trying it out. Maybe it's possible there are. Like I said, I am not a FEMA expert. I'm just an arbitrator that gets called in every now and then.
Mhm. Okay. Well, yeah,
Thank
these.
you. Appreciate it.
Thank you. Well, if this becomes state court, if this becomes the law in the states too, we're going to see a lot of things bubbling up. I think it'll be pretty interesting. But that's definitely an interesting nuance, William. Well, thanks so much, everybody. I really enjoyed having the opportunity to talk to you about this today. And unless there's somebody else, I guess we're done.
Thank you so much, Gray.
Thanks for having me, Tara. We love to have the opportunity to talk whenever we can.
And also, this recording will be on the administrative law section page as well at the State Bar. So thank you.
And I'm always happy to talk shop. If you get into these again, I've been really lucky to work in a place and have a client where we've had a lot of time with this. So I'm happy to talk shop. You can contact me by email if anybody's working with this.
Well, we appreciate that invitation to do so. And we thank you so much for your time today. And thank you all for joining us for this administrative law section lunch and learn. And I hope that you did, in fact, learn something. Thank you.
Like